The court case for this project is Fales v. Garst. This is for Pittsburgh State University, and I'm Sarah Cossey for Special Education Law. This case has to do with the balancing test and qualified immunity. The teachers, Dr. Jacqueline Fales, Mary Ann Common, and Eileen Scarborough, filed a lawsuit versus their principal, Lynn Garst. Fales and Common were special education teachers at the time, and Scarborough was an English teacher. All parties involved were employed by West Fork School District No. 1 in West Fork, Arkansas, and they worked at West Fork Middle School. The teachers filed a lawsuit to address their First and 14th Amendment rights. Their constitutional rights they were asking for also declaratory and injunctive relief, which means they would like to ask the judge to rule who has the rights and responsibilities in regard to each other, as well as the damages, considering the evaluations of the teachers within their contracts. The teachers collected data for their claims from 1995 through 1998. They claimed that Principal Garst violated the First Amendment rights of freedom of speech and the 14th Amendment rights for equal protection under the law. They accused him of harassing them, interfering with their ability to provide instruction to special education students, to provide the necessary supervision of students. He acted hostile towards them, lowered their evaluations, and threatened to lower evaluations. He instructed them not to discuss special education incidents that were occurring within the school with the media. He accused Scarborough of undermining him and going to his boss, the superintendent, as well as the special education coordinator. He accused Fales for being disloyal and untrustworthy employee, and he accused Common for being the leader of the opposition. Here is a list of other things that Mr. Garst was accused of during the court case. He did not allow teachers to adequately supervise and to protect medically fragile students that had special education related services, as well as other students. He had animosity towards the teachers, and he did not have actions related to the state's objectives to follow protocol with special education students. They accused him also of violating the First and 14th Amendment rights for the teachers. They put an injunction to refrain from violating those rights. And also, they wanted to have compensatory damages to the teachers for their mental anguish and emotional distress. He had accused them from the punitive damages for the teachers, the cost of the teachers' attorney fees, and other costs of the court case. Because of all of these accusations towards Principal Garst, a trial by jury was demanded by the teachers, and the judge granted the trial. The case was filed July 31st of 1998, and it was not completed until January 2nd of 2001. Here you see the case headers for each of the court cases. The first part of the court decision started at the District Court of Western District of Arkansas, Fayetteville Division, and it ended up with the U.S. Court of Appeals, the 8th Circuit. The District Court said they would continue to trial to the Court of Appeals, quote unquote, because the counsel for Principal Garst filed a motion for summary judgment with the District Court. Essentially, he asserted that even if the facts alleged by the teachers were true, as a matter of law, the teachers did not have legal grounds for a case against the principal, in part because Garst had qualified immunity. The District Court did not agree with Garst and denied the motion for summary judgment. The case was allowed to proceed to trial. The final decision of the courts was that the teachers failed to present specific incidents on how they were treated unfairly to others who were similarly situated. The judgment against Principal Garst was reversed to allow him a motion for a summary judgment. The court held the teachers' speech resulted in school factions and disharmony among their core workers and negatively impacted Garst's interest in efficiently administering the middle school. The biggest part of this court case was the court had to determine if the balance of free speech was of personal interest or of public concern. The constitutionality of the expressions of the teachers or against a principal rather than promoting the efficiency of the public service it performs through its employees. The courts were balancing the competing and conflicting interests. In closing, the court wrote, "Here is beyond peradventure that the plaintiff's speech caused the school upheaval. Because we believe that the teacher's interest in speaking on these matters was outweighed by the interest of efficient administration of the middle school, we conclude the district court erred in not finding Garst was entitled to qualified immunity." The biggest things that happened with this case is a lot of ethical issues were brought to the table. The ethics of the treatment of the special education students with needing better supports with transportation instructions, so a student did not need to walk farther away from their bus than needed. The lack of leadership to control staff relations in order to maintain a positive school culture and climate and atmosphere. Teachers were retaliated against within their evaluations. Conversations with staff about reporting internal school situations with outside news outlets, which would go through the communications director for the districts. There's possible violations of FERPA, with teachers speaking to news outlets as people could figure out which students they were talking about within their school. The superintendent tried to have a mediation between the staff and principal because of the bickering. Human resources may have needed to move around teachers or the principal to another school to fix the school culture. There was also teachers' loss of planning period due to the principal requiring the teacher to do so. This violates the ethics of the negotiated agreement of the teachers per the local NEA chapter. Decisions happen to be made without regard to IDEA laws within special education, and an administrator. Special educators are allowed to reach out to their coordinators to help with the conversations with the principal. The impact of this court case was definitely on special education procedures. In this case, there was a balancing test was used to show whether the teacher's free speech interest versus the employer's interest in efficiency. Courts will hear both sides of the teachers and their administrators can complain to the court without receiving punishment, so doors were open to litigation in order for teachers to advocate for the rights of their students. There would have been a case had the teachers focused more on their students' needs rather than their personal needs. Causing bickering in the building caused teachers to be against the principal and for the principal, so it really was a two-sided building. The court case gives some hope to being able to go to trial, and if the administrators are not tipping the scale, this kind of case would not have been thrown out. Hi, my name is Sarah Cossey, and for the past 7 years I've taught special education at the high school level in Kansas City, Kansas. This upcoming school year I will be teaching 6th grade special education in Kansas City, Missouri at the Hickmill Mills School District. I first started teaching in the preschool and elementary levels for 10 years before being interested in special education. My undergrad is in elementary education from Emporia State, and my master's degree is in special education from Baker University. I am currently at Pittsburgh State University for my educational specialist degree in special education leadership. I currently reside in Raytown, Missouri with my husband Chris and our 3 children, Maverick, McCready, and Lincoln.